Good morning, everybody. Thank you for the introduction, Karim. Yes, my name is Brad Boertje, and I am an adjudicator and arbitrator servicing the needs of the construction industry. Please bear in mind that I'm not an attorney, and my content does not constitute legal advice. Okay, it's my interpretation of the subject matter only. I'm often asked the question, what is the difference between a patent and a latent defect? And of course, this is a fairly common topic, certainly in my business, when people come to me with disputes on snag lists and items on a building project where there's a difference of opinion, etc. Okay, so we'll discuss that today. We'll discuss the difference between patent and latent defects. We'll talk about the common defect liability periods. Okay, I'll tell you a little bit about how the common law works. We'll discuss vicarious liability, which is a big word, but it's a simple principle. The legal doctrine of prescription, and something on two rights don't make a wrong in law, which basically means that if one party is in default, it's not a good idea to go into default yourself in order to address that default. It is a fairly long session, and given that we only have 20 minutes, we may consider breaking it into two. And then the second session will be held, I think it's the 11th of August. Okay, so let's go straight into it. For those attendees who are familiar with the JBCC, which is the most common building contract in South Africa, especially for the larger contracts, the JBCC describes a defect as any aspect of materials and workmanship forming part of the works that does not conform to the agreement and or construction information. Okay. So the contractor or subcontractor has an obligation to deliver a product meeting a certain quality standard. Now, I'll put the JBCC definition in, but that's generally the definition that applies on any contract. Okay. The first thing that comes to mind is that you often don't design the work. Okay. And somebody else does the design, an architect or a wet services engineer or a civil engineer, etc. So disputes often arise over what is a defect and what is a design flaw, isn't it? On larger contracts, there is a document called the preambles. Okay, some of you may be familiar with that, and it's like a specification and a methodology for the execution of all trades. It is similar to, I suppose, to the NHBRC manual. Okay, so I'm sure a lot of members or attendees today will be familiar with that document. And basically, it's just a code of what quality and specification you ought to comply with. Okay. As a note, contractors have an implied obligation in law to deliver a quality product. Okay. So it doesn't have to state, excuse me, on your quote or in your contract that you will deliver a quality product. You have an implied obligation in law to deliver that. Okay. Now, we don't want to be subjected to the common law because there's no definition of quality. Okay. That's why it's better to have a specification or a code that you work to. Then it reduces the subjective interpretation of what you need to deliver, and hopefully reduces disputes later. Okay, so what is a patent defect? It is one that is visible on a reasonable inspection of the works. Okay, so the architect or your client comes around and he inspects the work you've done, or anybody else for that matter, a reasonable person, okay, and it's clearly visible that there's a defect. Okay. In the larger contracts, the principal agent has an obligation to give you an indication of the quality he expects throughout the contract. Okay, so if you're working under the JBCC or the Master Builders Subcontract Agreement, remember that the principal agent can't come at the end of the job and now issue with a whole list of things that he's not happy with. Meantime, he's been watching you build like that throughout the contract. Okay? Just bear that in mind. Okay, so obviously it's not so easy when you're contracting directly with customers using a quote or the common law to define what a defect is. But what I want to impress on you is that it's visible on a reasonable inspection of the works. Okay. Now, a latent defect, okay, it can be the same defect that was visible, that was visible, but under circumstances it's not visible. Okay, so on a reasonable inspection, you didn't pick it up, but it was there. Okay, and that is, perhaps I can explain it like this. It's a defect that existed at a time, but was not visible or easily identifiable, or it was concealed. Okay, innocently concealed. Okay, you can't conceal the defect on purpose, and it only manifested itself later. Okay, so if you take an example of a waterproofing installation, maybe you had to do some torch-on waterproofing and you didn't do it properly. Okay, there's holes in it that you can't see, or the laps haven't been done properly, or some work hasn't been executed. But on a reasonable inspection of it, it looks perfect. Okay, but the defect exists. A year later, that defect manifests itself. The point is, the defect was always there. Okay, so in that scenario, that is definitely a latent defect. Okay. The important point to note that they are actually the same. Okay, it's just when they are identified or noticed. Okay, that is the difference between patent and latent. One you can see on a reasonable inspection, and the other one only manifests later. Now, it's quite common that the opinion of an expert will be required to give his opinion on if a defect is a defect. Okay. For example, has the maintenance been done? Okay, so if we go back to my waterproofing example, and there's a requirement in your contract that every 3 years they have to do maintenance to the waterproofing and they haven't done it, well, then it's not a defect. Okay, if it then fails due to a lack of maintenance, doesn't qualify. Okay, it's another defect at play. So what often happens is you have an underlying element or part of a structure that was built previously. You apply your product or service on top of it. The defect's actually not in your installation, it's in the previous installation, but it manifests through your installation. That makes sense? Okay, that's not your problem. Of course, all of this leads to differences in opinion. Okay. What people often say to me is that in the JVCC or the MBSA or a lot of other building contracts, there's what is known as a 5-year latent defects liability period. Okay, and most people say to me, but that is an enormous long period of time for me to be on the hook for a defect. Okay, just to note that in a lot of state contracts, public works contracts, etc., they actually double up that time to 10 years. Okay, now obviously as time goes by, it is harder and harder to prove that a latent defect manifested from your original installation, isn't it? So the longer after you finish or you've achieved final completion, the harder it is to prove that you have to attend to a defect. But coming back to the point about the 5 years, okay? In the common law, there is in fact, no time period at all. Okay, so if you're contracting without a contract that has a defects liability period defined, your client can come back to you at any time in the future, whether it's 20 years later, and tell you that your original installation was defective and that defects only manifested itself now. Okay, and like I said, the longer, the more time that passes, the harder it is to prove, absolutely. But it's a good idea to introduce a latent defects liability period in your quote or your contract to contract yourself out of the common law. Okay, and there's no reason why you can't try your luck and make it 3 years, for example. Okay, but my opinion is that it's something you need to do. You are often called upon, I'm sure, to provide workmanship and material guarantees, I'm sure, and those workmanship and material guarantees are basically a confirmation that you will attend to your defect liability obligations. Okay, that's what it means. So you don't actually have to have a workmanship and material guarantee. You're obliged to come and fix defects in any event. And like I said, in the common law, you're expected to provide a product that meets a standard which a reasonable person would consider to be the standard to be delivered. Okay, so I'm going to move on to the concept of prescription. Okay, prescription is a common law principle which I'm sure many of you have heard of. Okay, so in the common law, the various periods of prescription are defined in the Act. Okay, but the most common one is 3 years. Okay, so most commercial transactions carry a 3-year prescription period, and what that means is that if you have to take action against somebody or a business to rectify something or to demand something that arose from a contract, okay, including and most commonly the payment of a sum of money, okay, you have 3 years to launch that action from the date the debt arose, and that debt can be a money debt or a performance debt. Okay, so it therefore goes on to say that if a latent defect arises in your works, okay, the person who is demanding you to rectify it has 3 years, and it's exactly 3 years, okay, to notify you to attend to the rectification of that defect. So even if you have a 5-year latent defect period and your defect arises in year 2 or year 1, okay, and you only get notified more than 36 months after that, notwithstanding that you're still within the period, you won't have an obligation to attend to it because it wasn't notified timeously. I hope that makes sense. Okay, sorry, I've covered the stuff on that slide. Okay, and just the last bullet there, as with all things in law, it's open to subjective interpretation. It's common for differences of opinion to arise. Okay, the only thing that interrupts prescription, okay, is a court order, or for example, the launching, should I say, of litigation or arbitration proceedings or adjudication proceedings. So just remember that if you find yourself in a situation where you may have to demand some money or something from somebody else, you can't just make phone calls and write letters. Okay, if you do that and more than 3 years pass, you'll be found wanting. So at some point you have to step it up and actually take formal action against someone, especially if they owe you money. Okay, I think, Karim, we are going to finish today, so I'm going to carry on and get finished. Okay, so 2 wrongs don't make a right in law. Okay, so what I often hear is somebody will phone me and say, I haven't been paid by the contractor, I'm leaving site today. Okay, now you can't do that, because if one person breaches a contract, the remedy is not to breach it yourself, to try and make it right. Okay? 2 wrongs don't make a right. Each party has an obligation to do something. You have an obligation to deliver plumbing works, and your client has an obligation to pay you. Okay? If your client doesn't pay you, then there is normally a remedy or a process that you have to follow to get them to pay. So if you're working in the JVCC, and there's no reason why you can't do this on your own terms and conditions, it goes like, if you don't pay by the agreed payment date, I will put you on notice to pay. And after 3 days, if you haven't paid, I will then lawfully stop working. Okay? And I will then only resume working once you make payment. By doing that and following the process, you keep yourself out of breach. Okay. So it's perfectly possible for both parties to be in breach at the same time. Not a good idea, because if you are working under the JVCC or the NBSA or FIDIC or any of that standard form agreements, you will find yourself in a position where you can't, for example, cancel the contract for their breach because you are also in breach. Okay. So make sure that you always keep yourself out of breach when you are addressing somebody else's breach. Okay. As a final point there, I put there, all work has to be entirely complete. And just to expand on that, in the common law, your client actually has no obligation to pay you until you have finished everything to 1000% complete. Okay, so just remember that too. That's why it's important for you to define milestones for payment. Okay. That brings us to the end of the session, actually. So I did cover it quite well. I've just put a last slide up there for the attendees. Don't forget, I have some courses on the LMS that some of them attract big CPD points. So if you're interested in learning more about the commercial aspects, there's some courses you can take. Maybe just a word of advice to everybody is that, regardless of whether you're a domestic plumber or you're working for a contractor, make sure that you have a contract in place. Okay, you can't just work off the back of a cigarette box. You must have, even if it's a 1-page contract, you must define your payment terms. You must have found the defects. There's certain mandatory things you have to have. So my recommendation is, just bear that in mind when you're contracting, to have a solid contract to protect you. Thank you.